A very warm welcome to the second National Convention of Insolvency Professional and Registered Valuers, hosted by ICSI jointly with ICSI Institute of Insolvency Professionals and ICSI Registered Valuer Organization. It is indeed a privilege to have all of you here as we gather to deliberate on the theme, Insolvency and Valuation, Navigating Challenges and Future Pathway. This esteemed event brings together leading minds from the judiciary, government, industry, and academia to share their insight on the evolving dynamics of insolvency and valuation in India. Ladies and gentlemen, thank you for being part of this convention. Also to those who have joined us today live virtually. We would also like to thank our sponsor, RRR Insolvency Service Experts LLP and Primus Insolvency Resolution and Valuation Private Limited for supporting this convention as industrialist sponsors. Our esteemed dignitaries for the inaugural session has arrived, and it is my honor to invite them to the dais. Ladies and gentlemen, please join me in welcoming them with a resounding round of applause. Shri Mahendra Khandelwal sir, Honorable Member Judicial NCLT. Shri Anita Shah Akela, Joint Secretary, Ministry of Corporate Affairs. Honorable Justice Shri M.M. Kumar, Founder President of National Company Law Tribunal and former Chief Justice of Jammu and Kashmir High Court. C.S.B. Narasimhan sir, President ICSI. Shri P.K. Malhotra, Chairperson ICSI IIP. C.S. Manish Gupta, Immediate Past President ICSI and Program Director. And C.S. Jatin Singhal, Chairman ICSI NIRC. A very warm welcome to all our dignitaries on the dais. Satyam Vada Dharmam Chara. Speak the truth and abide by law. The motto which ICSI and its members follow in the letter and spirit uphold the torch of corporate governance profession in India. As we begin the day, I would like to request all to rise in your position for the motto song of ICSI.
उम्मीद के अंबर में हम बन के खिले जो रोशनी कह देंगे हम संसार को कोई लक्ष्य नामुमकिन नहीं ज्ञान के और न्याय के हर राह को थामे हुए चल पड़े हैं झूम कर बस गीत ये गाते हुए सत्यम वद धर्मम चर सत्यम वद धर्मम चर सत्यम वद कदमों की हर एक गूंज में बस जीत का एहसास हो राष्ट्र प्रगति पथ पे हो और आत्मबल की आस हो जब भी चले इस भाव से खुलते गए हैं रास्ते आवाज हमने दिल से दी है गीत ये गाते हुए सत्यम वद धर्मम चर सत्यम वद धर्मम चर सत्यम वद धर्मम चर हर उन्नति के रंग में हर भारतीय हाथ हो उद्यम हो या उद्योग हो हर और अपना साथ हो जाना शिखर तक है हमें सच की तलाई थाम कर हम जीत के सुर छेड़ेंगे गीत ये गाते हुए सत्यम वद धर्मम चर सत्यम वद धर्मम चर सत्यम वद धर्मम चर
Thank you. Now may I request following dignitaries to present a warm token of our welcome to our distinguished guest. I request C.S.B. Narasimhan sir to present a planter and shawl to Shri Mahendra Khandelwal sir. A big round of applause, please. Now I request B. Narasimhan sir to kindly welcome Ms. Anita Shah Kela ma'am with a planter and a shawl. I again request C.S.B. Narasimhan sir to present a planter and shawl to Honorable Justice Shri M.M. Kumar sir. A big round of applause, please. I request again, sir, to welcome Mr. P.K. Malhotra with a planter and a shawl. Thank you, dignitaries. Before we begin, let me have the honor to introduce our distinguished dignitaries on the dais who will set the tone for today's deliberation. We are graced by the presence of Honorable Shri Mahendra Khandelwal, Sir, Member NCLT, with decades of judicial experience. His contribution to resolving insolvency dispute and his perspective on emerging challenges are invaluable. Today, we are also privileged to have among us Srimati Anita Shah Akela, Joint Secretary, Ministry of Corporate Affairs, whose dynamic leadership has been instrumental in policy formulation and implementation for the corporate ecosystem. Her presence today reflects the Ministry's unwavering commitment to strengthening India's insolvency framework. We are privileged to have Honorable Justice Mr. M.M. Kumar, Founder President of National Company Law Tribunal and former Chief Justice of Jammu and Kashmir High Court, as one of our esteemed special guests. Justice Kumar has played a pivotal role in shaping India's insolvency jurisprudence, and his presence today is a testament to his enduring commitment to the cause. We have C.S.B. Narasimhan sir, President ICSI, a dynamic leader with a strong commitment to strengthening the ICSI vision. He has been at the forefront of initiatives aimed at empowering governance professionals. He will address us shortly, sharing insight that will inspire and guide us. Next, we have Mr. P.K. Malhotra, Chairperson of ICSI IIP, a distinguished legal luminary and a former Union Law Secretary. Mr. Malhotra has made significant contribution to the legal and governance ecosystem. He will present the progress report of ICSI IIP, highlighting its stride and future vision. C.S. Manish Gupta sir, immediate past president of ICSI and program director for today's event, known for his dynamic leadership and visionary approach. C.S. Manish Gupta sir has been instrumental in driving initiatives to strengthen the governance framework of this profession. His visionary leadership and exemplary dedication has curated this landmark event. Under his guidance, the program organizing committee has worked tirelessly to ensure the success of this convention. He will soon deliver the welcome address to officially commence this convention. And C.S. Jatin Singhal, the Chairman ICSI and IRO, a committed professional and a dedicated leader. C.S. Singhal has been actively contributing to the growth and development of the northern region. His efforts reflect a steadfast commitment to advancing the profession. Ladies and gentlemen, a special thanks to all our participants, stakeholders, and attendees who have joined us today to make this event a grand success. Without further ado, let us embark on today's journey of knowledge and dialogue. And to begin, I now invite C.S. Manish Gupta sir, the Program Director and immediate past President of ICSI, to formally deliver the welcome address and also to introduce the theme to the audience, please. Sir, may I kindly invite you to please deliver the welcome address. Thank you.
Thank you, Abhinav. Good morning. Dignitaries present on the dais, Shri Mahendra Khandelwal ji, Honorable Member Judicial, NCLT. Madam Anita Shah Akela, Joint Secretary, Ministry of Corporate Affairs. Honorable Justice M.M. Kumar sir, Founder President, NCLT, and former Chief Justice, Jammu and Kashmir High Court. President ICSI, Shri C.S.B. Narasimhan. Shri P.K. Malhotra ji, former Law Secretary and Chairperson, ICSI IIP. Jatin Singhal, who is Chairman NIRC. My Central Council colleagues who are present, Suresh, Dwarkanath ji, Manoj Purbe, NPS, acknowledge the presence of past President ICSI, Nesar sir. We also have with us former NCLT member, Rajesh Sharma ji. All the NIRC team who are present here in this hall. delegates, participants joined in person as well as those who have joined virtually. At the outset, I welcome you all to the second National Convention of IP and RVs being organized by ICSI jointly with the Institute of Company Secretaries of India, IIP, which is the extended arm of ICSI for the registration of IPs, as well as the Registered Valuer Organization, which is again an extended arm of ICSI. I also acknowledge the presence of Vineet Chaudhary, former Central Council member, ICSI. Friends, you must be wondering why this National Convention is being organized, because we do have other various programs in the domain of ICSI. So last year we started with the unique concept of having the National Convention for IP and RVs, because till that time we were having various programs, National Convention for members, a separate program for PCS for their capacity building and handholding. We thought fit, our council thought fit to have a separate program altogether for the capacity building, handholding, and to discuss the recent reforms which are there in the domain for the insolvency professionals and registered valuers. With that thought, we started with this unique concept of organizing a separate convention for the IPs and registered valuers. Today, we are fortunate to have with us our distinguished guests who have spared their valuable time for this conference, and I am sure the words of wisdom they are going to share that will surely motivate all of us and provide a way forward in the field of IBC, and many of our participants are registered as IP and RVs, so they will surely get to know what are the recent developments in the field of IBC and registered valuation. Friends, at ICSI, we are regularly discussing and focusing on the development of IPs and RVs. And one such discussion I really would like to share, because I am there in the IIP and RVO as director. So one such discussion is we will be very soon going to make a representation to IBBI to have a uniform fee structure, because up to this time, all guidelines, rules are uniform for all three IIPs, be it disciplinary, be it registration, be it CPE, everything is uniform for all the registered IPs, irrespective of to which IIP they are registered. So we have resolved to give a recommendation to the IBBI as well as to the ministry to have a uniform fee structure for the IIP, so that there should not be any deciding criteria per se for the registered IIP to register with one such IIP, because all three IIPs up to this time are having different fee structure for registration of IPs, RVOs, and IP, which are the insolvency professional entities. So that is one thing which I was looking to share. Another thing is this year we have formed a task force on NCLT, and we had prepared a report for various practices being adopted by the various benches of NCLT, and very soon we will be handing over that report to the NCLT president, and one copy would also be served to the Ministry of Corporate Affairs. Madam, because various benches of NCLT are having various practices, different diverse practices. So we wanted to have a uniform practices to be established at various benches of NCLT. So that report has been prepared by ICSI, and very soon we will be handing it over to the concerned authorities. Another, I'm really happy to share, that was a long cherished dream of ICSI to have our own NCLT Practitioners Association. So ICSI has come up with a Section 8 company, wholly owned Section 8 company of ICSI, wherein we have, will be having an NCLT Practitioners Association, and all members of ICSI are eligible to join, and we are looking to support the NCLT benches all across India. We'll be looking for the space, the library to be set up at all benches, and through this NCLT Practitioners Association, our intent is to handhold at the ground level wherever we will be able to provide the support to the benches at large. Uh, Before I conclude, I really acknowledge the support and contribution being extended by our past President Nisar Ahmed ji in organizing this program. A big round of applause for Nisar ji. At the same time, the contribution being made by the team, Rajesh Agarwal ji and Prashant Sarangi. They are the men who are behind this entire show. They are organizing and making all the efforts for the successful organization of this program. I hope the discussion which are going to be shared in today's conference would benefit all the delegates, all the participants, and there would be many takeaways out of this discussion. Thank you very much for your participation, and once again, welcome you all to the second national convention being organized by ICSI in association with ICSI, IIP and ICSI RVO. And I would like to thank all the distinguished guests who are present here and would be sharing their words of wisdom with the participants. Thank you very much. Thank you.
Thank you, CS Manishkrita sir, for your inspiring words and for officially welcoming us to this significant event. Now, to share the progress report of ICSI IIP, we have the privilege of inviting Mr. P.K. Malhotra sir, Chairperson of ICSI IIP. With his distinguished career in law and governance, Mr. Malhotra has been a driving force behind the ICSI IIP growth and achievement. Sir, the stage is yours to enlighten us with the milestone and accomplishment. Thank you.
Shri Mahendra Khandelwal ji, Honorable Judicial Member, National Company Law Tribunal, Mrs. Amita Shah Akela, Honorable Joint Secretary, Ministry of Corporate Affairs, Honorable Justice Shri M.M. Kumar, Founder, President, National Company Law Tribunal, and former Chief Justice of Jammu and Kashmir High Court, and also former member of the National Human Rights Commission also, which is not mentioned here, another important assignment which he has held in the past. Shri Narasimhan, President of the ICSI, Mr. Manish Gupta, immediate past President of the ICSI and Program Director for today's program, and Shri Sengalji, Chairman of the ICSI NIRC, who have taken up the responsibility of hosting this second national convention of which we are all participating. Other distinguished guests of the dais, ladies and gentlemen, a warm welcome to you on this second national convention on insolvency professionals and registered valuers. I stand before you as chairman of the ICSI Institute of Insolvency Professional, and in this national convention, I have been assigned the job of presenting the report of the ICSI IIP, the activities which we are doing, and I'm happy to share with you the achievements of the ICSI IIP, and I want to begin by expressing my heartfelt gratitude to all our stakeholders who have made the successful working of the ICSI IIP functioning. Before I come to that, obviously I would like to say something about the functioning of the IBC itself, because as Law Secretary, I had the privilege of looking into the draft, appearing before the Parliamentary Committee when this IBC was drafted. And it was a privilege for me that Shri Mahendra Khandelwal ji was also working in the Law Ministry at that time. And he was also thickly involved in that. And I think that experience is also helping him in giving very good orders while sitting on the bench in the NCLT. Now, I'll just start my talk with the observations made by President of India, Shrimati Draupadi Murmu ji, in her budget speech during addressing the Parliament, when she said, and I quote, 10 years ago, to save India's banking sector from collapsing, the government brought banking reforms and made laws like IBC. Today, these reforms have made India's banking sector one of the strongest banking sector in the world. Our public sector banks are robust and profitable today. Profits of public sector banks have crossed rupees 1.4 lakh crore in 23-24, which is 35% higher than last year. The strength of our banks enables them to expand their credit base and contribute to the economic development of the nation, unquote. IBC is now, as all of know, is in 8th year of operation. And as per latest published data on the news bulletin of IBBI, till September 2024, the creditors have realized 3.55 lakh crore under the resolution plan. The creditors have realized 161.11% of the liquidation value. Under CIRPs, 8,200 cases have been admitted, of which 1,068 concluded with approved resolution plan, 2,341 were closed back to the system, and 2,630 were liquidated. Around 78% of the CIRPs ending in liquidation were earlier with BIFR and or defunct, and the economic value of most of the corporate debtors had almost completely eroded even before they were admitted into CIRP. Total 79 cases out of 2,630 cases were closed by sale as a going concern under liquidation process. The liquidators of these cases realized 3,674.14 crore and the companies were rescued. Now, talking about the success of the IBC, even the RBI has stated that the asset quality position of the banking system has shown a remarkable improvement over the past few years. Specifically, the gross NPAs of scheduled commercial banks have declined from the peak of 11.2% in March 2018 to 2.8% in March 2024. A good part of that reduction is attributable to resolution processes enabled under the Insolvency and Bankruptcy Code. Before the start of this session, I was sitting with Justice Kumar, Mr. Khandelwal, and other members of the NCLT who are present here, and we were discussing and we were saying that definitely this law has brought the change. May not be to the expected or the desired results because of certain administrative reasons, but so far as the law is concerned, it has totally changed the scenario after 2016. But at the same time, I would also like to add that delays in the resolution process, be it procedural delay or delay by judiciary, low recovery rate for the creditors, delays in adjudication of fraudulent cases, interim finance issues, home buyers' recoveries during CIRP as well as liquidation, cross-border insolvencies are few examples wherein significant steps need to be taken to make it success nationally as well as internationally, which in turn will also help in encouraging foreign investment. So I think what we have done under IBC, what we have achieved, and what need to be done, I have tried to just make a passing reference before my report with regard to the IIP on this particular areas. Now, the ICSI IIP under the aegis of the Institute of Company Secretaries of India has played an important role in achieving objective of the IBC. Our membership has crossed 1,250 professionals, a diverse cohort that includes company secretaries, management experts, advocates, cost accountants, chartered accountants, and also the insolvency professional entities. Since its inception, ICSI IIP has been unwavering in its commitment to educate, monitor, discipline, train, and develop insolvency professionals. We have pioneered a number of initiatives, including the issuance of publications, monthly journal, daily learning course, and a range of educational programs such as intensive pre-registration educational training program, workshop, interactive session, and webinars that focus on practical aspects and challenges faced by the insolvency professionals. We have also developed in-house numerous publications, and I would like to refer some of them which have become very popular, not only with the insolvency professional, but with the people who are associated with this particular field in general. And some of them are Supreme Court on IBC, a compendium of landmark judgments of Supreme Court from 2017 to 2024, IBC Code and Regulations, Voluntary Liquidation, a handbook, Comprehensive Guide for Limited Insolvency Examination, IBC Digest, a compendium of research outcome, a compendium on insolvency professional. Another important publication which we have brought is IBC Learning Comes, which have become very popular. Judicial Regulatory Rulings for Stakeholders is another publication. Practical Aspects of Insolvency Law, which is the 4th edition we have come out. IRP, a handbook, again 4th edition of it has been published. Pronouncements under IBC and its issue analysis has also been done. And recently we have also come out with 100 landmark judgments of NCLAT's 2nd edition. And there are many more publications. I'm just highlighting only those publications which have been very popular with the users. Since the last convention, we have organized 90 programs for our professional members on pertinent themes for keeping them abreast with latest advancement in the field of insolvency law. ICSI IIP function to safeguard the rights, privileges, interests of IPs and stakeholders involved in the process. ICSI IIP has redressed around 130 grievances filed by stakeholders against members, and as a member of the Grievance Redressal Committee, I assure you that each and every issue is deliberated and redressed to the best of our ability. ICSI IIP is tasked to maintain a fine balance of safeguarding interest of its members and redress grievances of the stakeholder. It is also proactively monitoring and inspecting the insolvency professionals to make sure that they are working with complete independence and delivering competent professional services with highest professional conduct, since insolvency professionals are the key pillar for navigating the success of this code. We have technology-led query platform, learning management system, a user-friendly online platform offering e-books, expert-led online lectures, e-mock exam, e-journal, and compliance portal for the insolvency professional to enhance consistency, transparency, and timely outcomes. In the coming years, in addition to the statutory roles, ICSI IIP is planning to conduct mentorship program for new entrants, advanced certificate courses on IBC, interactive meet with bankers, and this will be done on pan-India basis, joint program with universities, industry associations, and other concerned entities. And I had discussion with the representative of my parent company, that is the ICSI, and we have decided that this kind of national convention need not be confined only to Delhi. We should go to the other regions also, and maybe the next convention which we will be holding, maybe in some other region, where other insolvency professionals and people interested in this particular area can also participate and share their thoughts with the Institute of Insolvency Professionals. We are planning to bring out new publications and statement of best practices for the benefit of the stakeholders. With international insolvency as well as bankruptcy organization, it is also under consideration. Looking forward, ICSI IIP aims to uphold the highest ethical standards in our professional endeavors, embracing continuous learning for benefit of its members, and collaborating effectively with all stakeholders to ensure the success of IBC and contribute to the growth of the Indian economy. I'm thankful to all the dignitaries on the dais, off the dais, delegates, and all other participants for their presence to enlighten us in the deliberation during the course of the day. Thank you very much.
Thank you, Malhotra sir, for the comprehensive report and for highlighting the remarkable progress of ICSI IIP. It is now my privilege to invite C.S.B. Narasimhan sir, President ICSI, to grace us with his address. Under his dynamic leadership, ICSI has reached new heights, driving innovation and excellence in governance, insolvency, and valuation practices. So the stage is yours to inspire us with your words, please.
Thank you. Good morning. Respected Shri Mahendra Khandelwal Sahab, Honorable Member, Judicial, NCLT, Srimati Anita Shah Akela, Joint Secretary, Ministry of Corporate Affairs, Honorable Justice Shri S.S. M.M. Kumar, Founder, President of NCA National Company Law Board Tribunal and former Chief Justice of the Jammu and Kashmir High Court, Shri P.K. Malhotra Sahab, what can I tell of him? He has been the chairman of the ICSI IIP and he's been a source of strength for all of us. And his attention which he pays to each one of whatever we do, whatever we discuss in the board meeting is something a treat to watch. And I'm sure, I'm sorry to say this, but he will be demitting office because he's had 2 terms of 3 years each in month of July. And he has asked us we need to look out for people, but I wish IBBI gives the further extension of 3 years as well, and by making the changes, suitable changes in the regulation, if need be. Manish Gupta ji, my immediate former president. In fact, one thing I want to say, the word past as a council has taken a conscious decision. The word past will not be used with any of the former members of the council or the president. The past denotes a very wrong meaning, and therefore I'll call him as immediate former president of ICSI. Jatin Singhal, chairman ICSI, NARO. I'm missing the presence of 2 stalwarts in the board, ICSI independent directors, Mr. Gopal Krishna Agarwal and Sri Ashok Mishra. Former president of ICSI, Mr. Nizar Ahmed sir, Rajesh Verma sir, former NCLT member. Former council member with whom I've interacted a lot, Vinny Chaudhary. All the current council members who are seated over here, 4 of them are here, and I think I don't have to take their names. They're doing a wonderful job. And for all the current regional council members from NARC, esteemed panelists, distinguished insolvency professional, registered valuers, friends, thanks a lot for your presence today. The Nizar Ahmed is chairing one committee for us, which is the task force on NCLT matters. I think, and he and his team, they are doing a commendable job. In fact, they have come out with a detailed presentation to be made to the NCLT for their consideration in terms of certain practices which needs to be uniform across all the benches. I think that is one. Plus, additionally, he was the one guy who was instrumental in getting the NCLT Practitioners Association started off. And I think these are small steps, and fortunately has come during my tenure as a president of the institute. So I'm mighty grateful to all of them for that. Thank you. It is with immense pride and joy that I welcome you all to the 2nd National Convention of Insolvency Professional and Registered Valuers. At the outset, I extend my warmest greetings and wish you and your family a very happy and a prosperous new year. I pray that 2025 be a year of full of opportunities, achievements, and growth for each one of us present over here. As ICSI President, I have with immense pride witnessed the blossoming of the IBC and the vital role of insolvency professionals and registered valuers who they play in it. Today, we stand at a crucial juncture where one can reflect on achievements, grapple with challenges, and embrace expectation to chart the course for a brighter future. The theme of this year's convention, Insolvency Valuation, Navigating Challenges and Future Pathways, aptly reflects the evolving and crucial role the insolvency professional and registered valuers play in our economy. This convention serves as a platform to foster meaningful discussion, share knowledge, collectively explore innovative solutions to the challenges which we face. As insolvency professionals and registered valuers provide credibility and effectiveness to the IBC process, your expertise directly impacts economic stability, job preservation, and business revitalization. However, we recognize the challenges you face in terms of resource limitation, complex cases, adequate remuneration, and the demand for continuous professional development. As part of IBC ecosystem, we must address these issues collectively to ensure economic ecosystem supports your growth as well. The Insolvency and Bankruptcy Court, now 8 years old, has been a transformative force resolving stress assets across industries, both from steel and MSME to real estate and entertainment. The era once termed as defaulters' paradise is now history. Till March 2024, as per the information provided to me, more than 28,000 applications for initiation of resolution process of corporate debtors having underlying default at the value of more than 10 lakh crore were withdrawn before the admission of the resolution application. This milestone underscores the IBC's robustness in resolving dispute mechanism process. There have been recent advancements by IBBI that are helpful for the IBCI framework. Streamlining the CIRP and liquidation process, introduction of VRIN for valuation reports, protecting home buyers' interests by allowing separate resolution plans for different projects and exclude certain properties from liquidation, mediation option for operational creditors before filing insolvency petition under Section 9 of IBC, etc., which are indeed commendable. I am delighted to announce the launch of the latest publication, Resolving the Unresolved, Success Stories of Insolvency Professional. This book celebrates the resilience and innovation and dedication of our insolvency professionals. This convention provides a unique opportunity to learn from experts, share best practices, and gain new perspectives. Panel discussion, workshops, and case studies will offer a comprehensive understanding of the current trends and challenges. Our esteemed speakers, drawn from diverse fields, will provide insightful perspectives and ignite crucial discussions. As we navigate the complexities of the insolvency valuation, let us focus not only on challenges but also on the remarkable progress we have made. Together, we can unlock the true potential of IBC, fostering a robust financial system and driving economic growth. I urge each one of you to prioritize restructuring and revival over liquidation wherever possible. Invest in capacity building, technology integration, and stakeholder collaboration. Leverage this convention as a springboard for innovation, knowledge sharing, and meaningful connections. On behalf of ICSI IAP and ICSI RVO, I extend a heartfelt gratitude to all the participants, and let this convention be a catalyst for the transformation and a testament to our commitment to building a transparent and a fair insolvency ecosystem. Thank you once again. I'm wishing you all the best. Thank you.
Thank you, B. Narasimhan sir, for your motivating address and for sharing your vision for a progressive and robust professional landscape. Ladies and gentlemen, it's now time for a special moment, the release of ICSI IIP's publication. These publications showcase the dedication and expertise of insolvency professionals and valuers in resolving complex challenges and shaping the future of the profession. I request the Secretariat of ICSI IIP to kindly arrange for the release at the hands of our guest. May I now request all the dignitaries on the dais to kindly join for the formal release of these publications. It is time for the first release, and I request CS NPS Chawla sir to please be on the dais. Council member, Central Council member ICSI. Yeah. It is the souvenir of the second National Convention of Insolvency Professional and Registered Valuers. It commemorates the occasion. Institute has come out with this souvenir, which contains the information about the theme, sub-theme, about ICSI, ICSI IIP, ICSI RVO, and theme articles. A big round of applause. Now I request CS Nisar Ahmed sir to please come on the dais. Next is the book titled Resolving the Unresolved, a collection of success stories of insolvency professionals. This publication is a compilation of 10 inspiring stories of insolvency professionals, showcasing how professionals have navigated complex legal, financial, and operational hurdles to ensure that the business get a fresh lease of life while safeguarding creditors' interest. This publication would not have been possible without the dedicated contribution of the esteemed authors and our IPs. A big round of applause. Thank you, dignitaries, for unveiling these significant publication. We now move to a special part of this inaugural session. It is an absolute honor to invite Honorable Justice Mr. M.M. Kumar to address his august gathering. Honorable Justice Shri M.M. Kumar has over 40 years of experience in the legal field, first as an advocate at the bar and later as a judge of Punjab and Haryana High Court and a Chief Justice of Jammu and Kashmir High Court, and then as a President of National Company Law Tribunal. With over 4 decades of experience in law and his pivotal role in shaping India's insolvency framework, his insights are truly invaluable. So we are eager to hear your esteemed views, please. A big round of applause.
Good morning to everybody. Shri Mahendra Khandelwal ji, Honorable Member, Judicial National Company Law Tribunal, Shri B. Narasimha, President ICSI, Shri Manish Gupta ji, Immediate past President ICSI, Mr. P. K. Malhotra, Chairman ICSI IIP, Shri Jatin Singhal, Chairman ICSI Nero, Shri Rajesh Sharma, former member National Company Law Tribunal, Shri Nasir Ahmed Saab, esteemed panelists, distinguished insolvency professionals, registered valuers, legal experts, colleagues, ladies and gentlemen. It is a great privilege to address this august gathering this morning in this hall. We have gathered to discuss, to look back and reflect on the significant growth in the insolvency ecosystem in India under IBC regime and reaffirm our pledge to promote, foster and enable IBC to succeed. I don't address you from the lofty heights of legal pronouncements, but from the very heart of the swirling rapids, the dynamic realm of the Insolvency and Bankruptcy Code. As an NCLT founder president, I am a fellow voyager alongside you, navigating the turbulent waters of distressed assets and charting a course towards resolution. Witnessing your dedication from restructuring business to maximizing value fills me with immense pleasure, respect and admiration. Friends, if we look back, pre-IBC regime, but we used to have. The NPA were ballooning. NPA, if you look at the data, in 2014-15, in fact data is available of 2009, more than 11.5 thousand crore. And the system prevalent at that time was ICSI 1985. Companies Act 433E. But it used to happen, any Sikh industry would prepare a scheme and go before BIFR, an institution created under ICSI. And there used to be section 22. If the scheme prepared by the Sikh industry is admitted by BIFR, then no recovery could be effected from the industry. Then the appeal was provided to the IFR and the cases would drag on for more than 10-15 years. What was the principle? Take loan to pay loan, evergreening. Take loan to pay loan. There was no accountability fixed. As a result, NPA ballooned to 11.5 lakhs crore. This was in this scenario when Insolvency Bankruptcy Code was enacted. Singapore was able to enact it a year before us, but we enacted in December 2016. I remember the then finance minister, Mr. Jaitley, was in Japan. He gave a call to the Secretary, Corporate Affairs, that I want to see that NCLT start working from 1st of June 2016 because IBC is going to be operational. So the Secretary rushed to me. I said, there is hardly any infrastructure. Then the Secretary insisted. Then I said, okay, I have some experience of running the court during floods in Jammu and Kashmir. So even at that time, I had told the governor that I don't need much. I need table, chair, pen, paper, a stenographer, and few books. So I thought that experience I should invoke. And we started whatever infrastructure, whatever the manpower was. That was 1st of June 2016. Then IBC came 1st of December 2016. Again, same question, infrastructure. I mean, if I won't say anything, the other members would agitate. But somehow or the other, we were able to carry on and we were able to produce good results. We have people like Mr. Ajay Sharma, who is in the audience, a member working. So they produce, the teamwork was very, very good. And the ICSI regime was the thing of past. We traveled a long way. It is now 8-year-old legislation. If I start counting the achievements, our President, Mr. Narasimha, have pointed out 28,818 applications which are responsible for settling 10.22 lakhs crore. These 22,818 applications were withdrawn under 12A before admission. And it involved the amount of debt, 10.22 lakhs crore. And financial year 2024 have seen the record number of resolutions, plan approved, 269, which is 42% up than the last year. So the credit goes to our members, our president, like Mr. Khandelwal, who are here, they're working very hard. But the challenge is, even today, delay. From 180 days, we went to 240 days. Now 330 days is the statutory limit fixed. We have not been able to achieve that. Still, the average period taken for finishing a case in the NCLT is 679 days, average period. How to curb it? That is a big challenge. I think this challenge can be met, very easily it can be met, if the presiding officer are able to put a limit on the arguments, because you see, every presiding officer, every bench has its own style of functioning. Some judges like oral arguments, it may take 2 days. Some judges say 2 hours, you argue main points, rest you give written submission, we will consider. So that some system can be evolved that longish argument may be avoided in the court. Resolution professional, IPs, they have a vital role to play. You see, sometime resolution professional or COC, they start thinking that instead of taking it upon themselves, let us move an application. Have a word from the NCLT, we are safe. Many a time it happens. On the bench I used to observe that kindly don't do this. You are a responsible person. You examine section 30, under section 30, if resolution plan, answer all the question, 31 invoke, present it. Why application after application? Then opinion from advocates being taken time and again. So those things contribute to the delay. If we want to check delay, because sometimes delay is caused at the behest of corporate debtor. The suspended board, they keep on thinking that maybe he is able to organize something. So that is the main reason. But if you look at the disposal of the NCLT, it is phenomenal. See at the work being done by the NCLT. Ignore for a minute, don't see what is the pendency. See what is the disposal. See how much is the resolution. The members are working day and night. Then look at the shortage of members. Now 22 members have come. Allahabad bench was working part-time for jurisdiction A and B and C. Chandigarh bench was working for jurisdiction A, B, C. After lunch, same bench will hear cases of another bench. So, this always I have seen happening. Now the present president must be worried that how now 22 members have come. You can imagine the delay being caused in disposal of cases. So that is second aspect. The strength of the NCLT should be constantly maintained. It is nothing, see, nothing is left to imagination. If you have 62 members or 84, now it is 62 I think, 62 or 63. So you can contemplate, anticipate that how many members are going to retire in the year 2023, 2024. Process for recruitment must start well in time, because this tribunal is of such a nature which has vital impact on the economy and our image in the world. Therefore, it must be given priority. This tribunal at least should be given priority insofar as recruitment processes are concerned. Now, if I start counting that how many issues were settled by, NCLT, it is ever growing. Principles after principles. In 2017, question of limitation started. That when 3 years period will be counted for a person to come to NCLT. I took the view that from the date when the cause of action has arisen, simple. That is 3 years. If default has taken place in 2012 and the NCLT they are approaching in 2017, naturally I will say that this is time barred. And there were other remedies. If it is in SICA, then SICA transferred those cases to us. If it was before the High Court transferred those cases to us. So there was no question of limitation in those cases. But if a person is keeping quiet, a person who has a debt, say, of 2000, he cannot come to the NCLT and say that since NCLT has come into existence on 1st of December 2016, 3 years will be counted from that date. So when I took this view, the appellate tribunal reversed my view by adopting the logic that NCLT has jurisdiction from 1st of December 2016, therefore any cause of action even earlier, if it is within 3 years of 1st of December 2016, then it is within limitation. But happily, my view was restored by Supreme Court. So limitation issue was, settled. Then there were dirty dozen cases, popularly known as Bhushan Steel, SR, this, that, and other. We were able to solve all of them. Then those days there were, for example, in whether EPF, Employee Provident Fund, would be within the corporate insolvency resolution process or not. We took the view that no, it will be outside the CISR, so therefore it cannot be part of the corporate insolvency resolution process. This view ultimately was upheld up to Supreme Court. So there were so many others. Constitutional validity was upheld of IBC, various provisions were challenged in Swiss ribbons, 5 judges bench. So the 2-3 things which I wish to refer, there was a threshold of 1 lakh earlier. Under section 4, proviso, there was a threshold of 1 lakh that person who has to recover a lakh of rupee or more could have come to NCLT. Now this 1 lakh was increased to 1 crore. What was the impact? The impact was MSME sector suffered a big setback. MSME sector used to have dues something like 20 lakhs, 30 lakhs, 50 lakhs. So MSME sector suffered a huge setback and it has not been able to recover till date. The rationale is also not very good for increasing it to 1 crore. Why I say this? If you look at the English Act of 1986, Insolvency Bankruptcy Code in England, what is the threshold there? 100 pounds. Because would you consider me insolvent if I owe you 100 pounds, or if you consider me insolvent if I owe you 50,000 pounds? I am more insolvent if I owe you 100 pounds. If I am not able to give you 100 pounds, how can you? That is why lower threshold is kept. So the MSME sector was sought to be rehabilitated by incorporating a separate chapter of pre-pack. How many pre-pack cases of MSME sectors are there in NCLT? Not more than 5. And 2 of them from my chamber. So I don't know. I have seen Prime Minister taking very keen interest in MSME sector. If well-intentioned legislation is brought, instead of this 1 crore, other reason given was for bringing 1 crore was rush of cases. There is huge rush, but that is no answer. To judge the insolvency, jurisprudentially speaking, this is not the basis. You cannot say, tomorrow you will say 50 crore. And this has happened because there was delegation. It was not a parliamentary discretion use, it was by notification by the government because power was delegated. So I think this needs to be looked into by somebody in the days to come. The second thing which I wish to emphasize, which is not considered that seriously, information utility. In the beginning days, the question would be raised in various meetings in the North Block. Why you don't admit a petition under Section 7 within 15 days? There is a provision that admission should take place within 15 days. So I ask one question, that there has to be principles of natural justice complied with. How those could be complied with? Legislation has very wisely incorporated a chapter on information utility. Now, how information utility functions? Information utility asks all the banks to send them data of NPAs. Then the information utility serve notices to all the defaulters that this is the data we have received from your bank, you owe this much of amount, kindly explain whether it is correct or not. The principle of natural justice are complied with there and then. And according to the reply received from the debtor, the information utility will upload its website that this much of default is there. And that would be considered as a gospel truth by the NCLT. That is the scheme of the Act. But information utility was set up only in 2018, I think. Now I have been told that it is working very smoothly, although some of its data is not that authentic, but it needs to be strengthened in order to bring efficiency, in order to curb delays. As far as the valuation sector is concerned, valuation has been neglected because we are dependent on the property dealers for valuation. In the past, 2017 IBBI brought rules and regulation. I was leading a delegation to London with Dr. Sahu and other 7 members, and we came across an institution of valuer, and they published a book called RICS, which Dr. Sahu also carried with him. But rules were published in 2017 before that book could be utilized. I think the valuation has been rightly taken up by this body. It is a very, very important issue. I came across a case where the land of a hotel hotel was assessed by virtue of its land only. So I was surprised that valuation report which has been given, it is only with regard to the land, and that is the valuation of the hotel, a running hotel. So I think some of these archaic practices of valuation have already been abandoned. That is the happy news. But still, in this sector, a lot required to be done. Valuation part, I think, needs to be looked into. Then, pre-pack should be encouraged. For MSME sector, pre-pack has been incorporated in the IBC itself. But for general sector also, I think the pre-pack should be encouraged. Now, what is the pre-pack? It is an informal process which is prevalent in England. It has been developed by the professionals. Now, whenever a company is indicating that its profits are coming down and down by every year, then when they are about to reach a danger mark, then they enter into some arrangement with another company or financial organization to bring in the change in the board of directors, that in case insolvency case is filed, then this pre-pack, this arrangement which we are making a year before, 2 years before, that arrangement would come into operation. So the day notice is issued by the insolvency tribunal in England, the administrator, as they call him there, like RP, will get into touch with the company, the corporate debtor, and they will produce the pre-pack. Overnight, there will be change of hand of the company structure, board of management, and there is no insolvency proceeding initiated. Assets remain intact, reduction of value remain kept at bay. All these factors save the company from going into bad name in the market. So this is another aspect, that if a company goes into insolvency and bankruptcy, in the market its name is sullied completely. Pre-pack also saved the name of the company being sullied in the market, and it saved its goodwill. Otherwise its goodwill is down the drain. There are so many other points, but I think the time won't permit me to continue. I just want to say one more. You see, the World Bank ranking for ease of doing business amongst 190 countries in 2016, imagine, it was 130 in 190 countries. What is in 2023? 63. It is majorly because of IBC. Mr. Malhotra has read the presidential speech reference to the IBC. So this is the reason that the economy has revived because of impact of IBC. IBC has brought financial discipline. It is no longer possible for any entrepreneur to borrow and escape repayment. And GRR award was given to India in 2018. 2017 Singapore was awarded GRR award, but we got it in 2018. And the plates say to recognize exceptional achievement in insolvency law and unprecedented development and judgment given by NCLT. That is the citation of the GRR award. Friends, our journey is challenging. It is full of achievements. It is evolving. Your cooperation, your dedication is admirable. Keep it on. We are not far away from the promised land. We are about to reach there, but little more patience, little more work, little more hard labor. Thank you so much. Thank you.
Thank you, Honorable Justice Kumar sir, for your insightful address and for inspiring us with your profound knowledge. Now, it is my privilege to introduce a distinguished guest whose contribution and expertise have been invaluable in shaping India's corporate and financial landscape. Srimati Anita Shah Akela ma'am, an esteemed member of 1996 batch of Indian Audit and Accounting Service, currently serves as Joint Secretary in the Ministry of Corporate Affairs. Her illustrious career includes pivotal roles such as Director General in the CAG Office, Delhi, Internal Financial Advisor at the Department of Atomic Energy, Mumbai, and Financial Advisor and Chief Accounting Officer of the Tirumala Tirupati Devasthanam Board. Srimati Anita Shah Akela ma'am has also been nominated as an ex officio member of the governing board of IBBI, representing the Ministry of Corporate Affairs. Her profound insight and leadership have been instrumental in advancing the objectives of Insolvency and Bankruptcy Board of India. Ladies and gentlemen, it is an honor to have her among us today. May I now invite Srimati Anita Shah Akela ma'am to kindly grace the dais and share her word of wisdom with us. Please join me in welcoming her with a warm round of applause. Thank you.
Namaskar, a very warm good morning to all of you and a very, very happy new year ahead. As we look on to 2025, we enter into the 9th year of the Insolvency and Bankruptcy Code, which was one of the biggest reforms of this government, along with the GST. And I would say that the IBC was a very successful reform because it completely changed the landscape of the credit system in the country. There was more of fear, less of willful defaults, because the one thing that we looked at differently from the other countries was that we went in for a creditor in control model rather than a debtor in control model, which exists in other countries. As a result of this, the healthy balance sheet of the banks that we see today is majorly because of this reform, and the RBI, as was already stated, has already put that across in its various reports that keep coming from time to time, usually in the month of December. So the recoveries that have happened through IBC form a major portion, major chunk, around 40 odd percent of the recoveries which are through other channels. We have SARFACI, DRTs, different channels which are there. IBC has formed the maximum space of recovery. So the credit for this goes to all the stakeholders, and I think we should all be proud of that. This is the NCLT, the IBBI, and more importantly, the insolvency resolution professionals, that's all of you. So as we stand today very proudly before everyone, even in the international conferences, the success of IBC has been lauded very often, and the recovery percentage that we talk of, or the amount that we've recovered against liquidation value or against fair value that we talk of, is just a tip of the iceberg. What is more important is the fear factor, which is leading to quick repayments and less willful default by people, which is probably not captured anywhere. The other thing would be the withdrawals that take place before either Section 12A withdrawals or withdrawals before admission that take place. That's another factor which is what the NCLT has actually contributed back to the economy without having to do so, without having to do anything. It's just the fear of losing the control of the company. So this is where we stand. And I keep mentioning everywhere that do not measure the success of IBC by the recovery that has come about, because we are not a recovery mechanism, we are more of a resolution mechanism. IBC is more a code of resolution than it is of recovery. And interestingly, IBBI had done a study which was there on their website in 2023. They had got a study done by IIM of about 550 companies, and how these companies have been resolved and how they have again put the companies back into the economic system where you don't have loss of jobs. There is a lot of contribution to the economy. So this is what IBC code has done. There have been, there have been a little setbacks from time to time. Vacancies, NCLT vacancies has been an issue. Let me mention it here that the ministry is well aware that the vacancies arise. We do do a 1 year, 2 year plan. We do look at what are the vacancies likely to arise. The process is a continuous one of filling of vacancies, and it is a long drawn process because a lot of rigor goes into the selection of members, given the sensitive nature of job that is and how difficult it is to really stick to the timelines and push the companies out of the insolvency and push them into a resolution mode. So this rigor takes a lot of time. Insofar as, in fact, it's very interesting that if you noted the budget speech of the Honorable Finance Minister last year, there was also a proposal to increase the number of benches and have special benches, especially for the Companies Act, because when the NCLT was formed, it was mainly for the Companies Act, and thereafter came in the IBC, and then the NCLT got formed by the IBC and its strict deadlines. And therefore, the mergers and acquisitions were also suffering. Therefore, a decision was taken to have separate set of benches for Companies Act. Another thing that we are looking at is we had a colloquium of all the stakeholders, NCLT, NCLAT, etc., because the Honorable Prime Minister wanted us to have a complete relook at the IBC code and what was ailing, because it was to perform at 100%, probably the performance was a bit less. So, Honorable Prime Minister wanted us to have a complete relook at how IBC is worked out. So, we had a colloquium inviting all the stakeholders, NCLT, NCLAT, RPs, IPs, lawyers. We had a colloquium in November 22 where we wanted to look at how we can make the IBC ecosystem work way better. As a result of this colloquium, we also came up with a report on the IBC ecosystem, a consolidated report, which was thereafter made into a discussion paper, which was floated by MCA in the Jan-Feb of 23. So in that, a lot of suggestions had come from the colloquium, which we again put back to the stakeholders. We got a number of comments. We got about 1,852 comments on the discussion paper that we had. The discussion paper was varying because we wanted in some places to even change the core of the IBC, that is the heart of IBC being section 53, where we were looking at probably you could have a threshold and the rest of the amount could be divided pari passu. And then we were also looking at having a separate this thing for real estate. We were looking at having a creditor-led mechanism for for other than MSME companies, there was a proposal to extend pre-pack mechanism to bigger companies. Thereafter, we've had a look at all the comments and all that, and the amendments are under consideration. There have been certain issues based on judicial pronouncements that have happened from time to time, especially the Vidarbha case, the Rainbow case, etc. So there have been certain issues that have arisen because of those kind of judgments, which are also proposed to be corrected through the amendment, which is going to make things way easier for the insolvency ecosystem to move on. So as I was saying, that the NCLT rules were being followed by the NCLT in the absence of any specific rule of how IBC could be taken up by the NCLT. So in consultation with NCLT, now we are in the process of making adjudicating authority rules, which is a part of the colloquium suggestion, discussion paper suggestions also, that IBC deserves a separate set of rules. You cannot look at IBC the way you look at other Companies Act or other things where time is not the essence, but for IBC, time is the essence. So this is something we've tried to balance, and shortly the government should be coming out with the adjudicating authority rules. Thereafter, we also, if you also recall that in the budget, an announcement was made for the integrated portal of IBC, integrated portal for the insolvency ecosystem, which we call as the IPI. So IPI was sanctioned recently by the Honorable Finance Minister, and we are in the process of getting the tender, etc. done. What is IPI? What do we look at in IPI? This would be of interest to you, therefore I need to bring this to your notice, that currently NCLT, NCLAT, IBBI, MCA and insolvency professionals, we all work in our different silos. The fact is that when a case comes up, when you have when a corporate debtor comes to the insolvency professional is to be appointed, the application is filed before the NCLT, then the process goes through the RP. And then RP has to from time to time continuously make different kind of regulatory requirements of IBBI have to be met, the requirements of NCLT have to be met. NCLT also requires to go through a lot of templates, etc., what has happened in the past. So all these things we propose to bring it into one integrated system. Is going to be a federated system. We are not going to touch the e-courts of NCLT, we are not touching the IBBI systems, etc., but it's going to be more of a case management system for the RPs, whereby you make a application through that to the NCLT on the e-court system, and whatever, as the progress is happening, the information goes to the IBBI, whatever is required, you have all the data and the system moves. As of today, I think NESL has some case management system and there have been certain issues in that. So this is something we are planning to improve upon. Whatever was the requirement there, we are planning to improve upon that, and we'll have a very data light kind of a system where the data will be pushed and pulled only where it is required. It will be properly role based. There was a fear in some of the IPs that probably there's too much of surveillance on that. No, that's not going to happen. We'll only take whatever data is required, that is IBBI requires certain data or NCLT requires certain data, so that kind of thing it will be moving on. And there's also going to be a linkage with the MCA 21 so that your filings, etc., can be done easily, whatever compliance filings require to be done. So this is under development. I hope in a year's time we should have it up and running. And then we are also looking at having something on WhatsApp where you can also have an app where you get the flags as to when your cases are coming up or what is next required to be done. It will have a claim management module, there will be an auction module. So a lot of things, so it's going to be your complete solution for the RPs. This is what we are looking at in IPI. Thereafter, there are certain things that In fact, insofar as the information utility is concerned, one, we are looking at the amendments for making the information utilities data to be adequate or to be sufficient to admit a case into the IBC. But on the other hand, the IBBI has also come up with a certain set of rules, regulations, which is helping in the authentication of the data in a way better manner than it was earlier. There is often a discussion that is held in the various international fora and even our in the parliament committees, etc., that there's a lot of delay in taking up the NCLT. There's a delay in admission. There's a delay in all the processes. So here we have been requesting the banks that the moment you see your default, please come early into the NCLT system, come early into the IBC system, because the more you delay, the value of the asset keeps coming down. So you're not able to then control the erosion of value. And we have even data to prove it. IBBI has put it up on their website also, that how the valuation, the value of the asset keeps coming down as the time for even filing an application increases. So that is one thing we are looking at. The other thing we are looking at is how to reduce the delays within the NCLT system, within the IBC ecosystem itself. So these are the two-pronged approach that we are looking at to tackle the delays in the system. But when we are compared with the international system, we always tell people that please do recognize that this is a creditor in control model where the corporate debtor the promoter ends up losing the company. So he tends to litigate way more than others would. Where if I were to get my company into insolvency process, then I would not litigate as much. But if it was to come, if somebody is pulling me, then I'm definitely going to litigate. So this is probably expected that there would be some kind of a litigation that happen. Now, insofar as the role of the RP is concerned, I would like to say just one thing here, that you are the doctors, to whom the corporate debtor comes to for revival. Your task is very difficult. Your task is very, different companies come with different problems, and you are basically master of all trades to that extent, because you need to know about various fields, various works. So your role being very crucial, it is very crucial that there should be continuous learning, there should be continuous professional education, and peer review should also be a part of your whatever activities that you take happen, that should continuously, you have to continuously keep upgrading yourself, especially with the international standards, what is expected out of you. I mean, if you could look at AI, blockchain, I don't know, there are various ways that your processes should be improved. In fact, we are also helping by the IPI to improve the processes that are there. Another issue is of buffet transactions, which are largely overlooked. So I would take this opportunity of being here to request you all to also look into buffet transactions. And in fact, there's a lot of value to be unlocked if the buffet transactions are also tackled. We are trying at the ministries and at the IBBI's end to see how best we can come out of it. If you all could also help us to find out how we can improve the unlocking of value of the buffet transactions, how we can get it back, and what would be required for the RPs to be able to pursue those transactions. That also would be wonderful. And with these words, thank you very much. It's been a pleasure to be here to listen to my past speakers, the speakers before me. So it's been a pleasure listening to all of you, and I'm available anytime if anybody has anything to say. I'm always available, so kindly drop in a mail or something, because I would really like to hear from you what are the practical difficulties that you're facing and where you would like us to improve. Thank you so much.
Thank you, Srimati Anita Shah Kela ma'am, Joint Secretary, Ministry of Corporate Affairs, for your insightful address and for inspiring us with your profound knowledge. Next, we are privileged to invite Shri Mahendra Khandelwal sir, Honorable Member Judicial of National Company Law Tribunal, known for his keen legal acumen and deep understanding of insolvency matters. His address will surely enrich our perspective. Sir, may I kindly request you to please share your word of wisdom with us. Thank you. A big round of applause, please.
Good morning, all of you. Honorable Madam Anita Shah, Honorable Justice Kumar, respected Shri P.K. Malhotra sir, President Narasimha sir, Manish Gupta ji, Mr. Singhal, Senior Advocate Shri Nagesh, Mr. Sharma, the former member, Executive Director IBBI, Mr. John Dinesh, all distinguished ladies and gentlemen, our colleagues. It's a matter of great privilege for me to be here before all of you. The present program is being organized by the Institute of Company Secretary Wing about the resolution professional and the valuers. I am not here as a judicial member NCLT, but I am here as the ordinary person having some kind of idea about these proceedings. Many of the persons who are sitting here, we have interaction on the daily basis in the courtroom, but here our discussion is not on the courtroom. Here we are just to discuss what is our role and what is your role in respect of how to achieve the goal of the IBC. The objective of the IBC is to have a resolution of the corporate debtor. Here, when we are talking about the corporate, we are not concerned about the issue of the personal insolvency. Just we are talking about the insolvency procedure of the corporate entity, principal, borrower, and guarantor. As Madam Shah has told, that it is not a recovery mechanism proceeding, but to have a resolution of the corporate debtor. And for the purpose of the resolution of the corporate debtor, the important pillar of this process is the resolution professional. Like in the case of ordinary administration of justice, when we talk about, we find that bench and the bar are the two important pillar of the administration of justice. But when we talk about this insolvency resolution process, apart from the tribunal and the bar, there is another pillar known as resolution professional. Role of the bar is mostly restricted till the admission or dismissal of the section 7, 9, 10 petition. Once a petition is admitted and a resolution professional is appointed, he takes an important role in the entire process of resolution. And from the stage of this taking over the management, constitution of the COC, receiving the claims, inviting the resolution plan, examine the plan, put up before the COC, put up before the adjudicating authority. In every stage, his involvement is involved. Without the active support, active participation of the resolution professional, this process cannot be completed effectively. And I would like to say that the role of the resolution professional and his involvement is much more than even the members of the bar. Why so? Because the counsel who represent a client, his duty is to put forth the case of his client. We all know that under the Advocates Act, Bar Council of India has many rules and regulations framed for the professional conduct. And as per those rules, an advocate is having his professional duty to protect the interest of his client legally. Therefore, it is not supposed from an advocate to say something before the court which goes against the interest of client. But for resolution professional, there is no client. He has to take the call, he has to take a decision which is in the best interest and which is just fairer. And the resolution professional has to place before the adjudicating authority as well as before the COC the true facts and true law. If the resolution professional does his professional duty effectively, all possible resolution will take place within the reasonable time. But if he fails to do so, it is not only the failure of resolution professional, but it is the failure of entire system. Everybody blames everyone. So my request is to my fellow resolution professional is that they should do their professional function effectively, professionally, and put forth all the facts and law correctly. Examine the claims legally and give proper advice to the COC as well as, if required, put his case before the adjudicating authority. Because what we have to see in these cases, what is happening in the ground. In many cases, suppose a claim has been filed before the RP. As per the law, if it is delayed, he can't admit the claim. But at least before communicating the same that because of delay he can't do, he has to examine and find a tentative view whether that claim as per the books of account can be admitted or not. Because as per the amendment in the regulation made by the IBBI, up to the stage of the plan is placed before the COC, they themselves can examine and put application before the adjudicating authority for condonation of delay. We have found very few applications comes like this. And resolution professional, when they seek, comes before the adjudicating authority, they should approach where it is necessary to approach. What is happening in many times, everything is been shifted to the adjudicating authority to take a decision. It delays the matter. And also thing is that applications are filed for many reliefs which perhaps is not in the domain of the adjudicating authority. For example, I am giving, many times I have seen an application filed by the RP, give direction to station house officer to register the FIR. To give direction to the registering authority not to register it. Is it necessary? Is it in the, when RP or files an application, he has to see that apart from IBC, there are plenty of other laws. It is correct that as per section 38, IBC will prevail. But all your legal luminaries understand, IBC will prevail if there is an inconsistent provision with any other law. But when there is a specific law to deal with a particular situation, why not exercise that? It is not a function of the adjudicating authority to pass such an order. And two provision I would say, section 60 subsection 5, rule 11 of the NCLT rule. In every application, these rules and sections are quoted, and we are supposed to adjudicate from the ground to the sky everything. Honorable Supreme Court in Gujarat Urja and many other judgments have laid down what is the scope of the section 60 subsection 5 and what is the jurisdiction of the NCLT. If many such kind of applications are not filed, perhaps the resolution process can be completed within the time frame. As far as we people are concerned, what is everywhere it is said that there are many times are being taken in the deciding the admitting or rejecting the section 7 application, taking time for approving or dismissing the resolution plan. Although it is correct, there is a 14 days time limit. But the Honorable Supreme Court has also said we have to follow the principles of natural justice. And this can only be process we have to follow with the help of the parties, with the help of the councils. There are some practical things. Even in a petition under section 9 Section 7 is filed, before issuing a notice, at least we have to prima facie satisfy that it is a case made out for the issuing notice. For that purpose, we have to hear the learned counsel on behalf of the financial creditor, the operational creditor. Sometimes there may be some defects in the petition. Sometimes learned arguing counsel or the person who will brief the case is not available. We have to give some time to them. Because it is a cardinal principle of the jurisprudence that whatever procedure we follow for deciding an issue, that procedure must be just, fair and reasonable. We cannot do a thing just for the, because there are two different things. Disposal of a case and giving justice in a case. Disposal may possible, token, somebody has come and we have passed an order, nothing. But at least we have to adjudicate those issues. It takes some time. So that's why there is an issue of delay comes. So when today we are discussing about the resolution professional, my request, one more request for resolution professionals would be that many times we find that somebody is not happy with the working of a particular resolution professional for the reason XYZ I am not going. And they sought replacement. Whether to replace or not, sometimes it takes 3 months, 4 months to decide that issue. The person who is a presently RP always contest. And there is a reason for contest. Because sometimes replacement is sought on the ground that he has done XYZ things. And if he accepts that XYZ thing, it will becomes for his professional misconduct. That's why he. So we have to decide those issues whether need to be. There are judgments of the Honorable Anclet also that whether he has to be heard or not to be heard. But a way out may be found. The way out is RP who is presently working, he may say that without going into the merits of the allegation or the counter allegation, decision may be considered. If a particular percentage of the member of the COC has decided particular thing, right, rightly or wrongly, in the commercial wisdom we don't go. If they have decided to replace, let it replace. Without going into account with the allegations made there. So that will be an easy thing. So that his, whatever allegation have been made has not been considered and adjudicated. So that may be a reason. So it will not cause any problem for him for his future assignment. So these are some, otherwise I have seen that as far as whatever we have achieved in the IBC for disposal of cases, for approval of the plan, liquidation, dissolution, etc., I must say that it could not have been achieved without the cooperation, without the efforts of the RP or the liquidator. Because even the resolution plan is approved, even thereafter, for the implementation of the plan, in the monitoring committee, everywhere, this resolution professional is there. So, same is the case with the valuers. Normally, valuers issue does not come in the open, but for approval of any plan or for consideration of any plan by the COC, the report of the valuers, what is the liquidation value of the corporate return is there, it is always mentioned, plan value, liquidation value, fair value, and normally two valuers does this, average is taken on the basis. Except in few cases where it is somebody disputes that, when we approve a resolution plan, we always take into account the valuation given by the valuers. Even the provision of the codes and regulation also mandates us to see what is the plan value, what is the liquidation value, what is the fair value. If there is a plan value is less than the liquidation value or the fair value, what is the justification, what is the reason? So the role of valuers in all these cases are very important. We presume that valuers, while valuation has done valuation, they have taken into account all the material available with them for arriving a particular valuation. There are, I'm not an expert in that accounting system, but there are various methods to arrive at a valuation. So therefore, valuer is also one of the important pillar of this resolution process. So I must say that all the persons who are present here, and I am seeing that many of them are discharging their function in different capacities. Some of them are, sometimes they appear as a lawyer, sometimes they are also the resolution professional or the liquidator, some are the company secretary also. So, for fully functional IBC, role of each is very much important, and we appreciate that whatever achievement has been done, it is all because of their endeavor, their cooperation, and their professional duties. I am not here to give any kind of lecture. As far as my working is concerned, I can't comment on my working. It is for you people to take a call, whether you are satisfied or not. But only thing is that sometimes you may not agree with my views when we express in the court, but that's our different functions. But only thing what will, in the last I would like to say that we all should do our professional function, whether in whatever capacity all of us are doing, even ourselves, in the best manner, as per our best ability, without any ill will and without any kind of confrontation with each other, so that the object of the IBC as well as object of the making our country as a economic hub can be achieved. With all these, thanks you, because already time is over. We have to go for other technical sessions also. Thank you once again.
Thank you, Shri Mahendra Khandelwal, sir, for an enlightening address and for sharing your invaluable expertise with us. Ladies and gentlemen, as we conclude this inaugural session, it is time to express our heartfelt gratitude to all our esteemed dignitaries on the dais with a token of thanks in the form of memento. So may I kindly request CSB Narasimhan, sir, President ICSI, to present a memento to Shri Mahendra Khandelwal, sir, Honorable Member, Judicial NCLT. A big round of applause, please. I also request President ICSI, sir, to present a memento to Ms. Anita Shah Akela, ma'am, Joint Secretary, MCA. Then, sir, please, it's a request to please facilitate Honorable Justice Shri M.M. Kumar, Founder, President of NCLT and former Chief Justice of Jammu and Kashmir High Court. Thank you. Now I request CS Jatin Singhal, Chairman ICSI NIRC, to please give a vote of thanks. Oh, apologies. I request President sir to facilitate sir with the memento. Now request CS Jatin Singhal, Chairman ICSI NIRC, to please deliver a vote of thanks. Thank you.
Thank you, Abhinav. I, CS Jatin Singhal, take this opportunity to present the formal vote of thanks of this inaugural session of Second National Convention of Insolvency Professionals and Registered Valuers sponsored by Primus and Rise. It has been an absolute honor for ICSI to have such distinguished guests with us today. NCLT Honorable Member Mahendra Khandelwal ji, Shrimati Anita Shah Akela ji, Joint Secretary MCA, Justice M.M. Kumar, former President NCLT and former Chief Justice of Jammu and Kashmir, Shri P.K. Malhotra ji, Chairperson ICSI IIP. I also take this opportunity to thank all the staff at the back end of from ICSI headquarters and regional office, and my regional colleagues who are present here, the past President and past Chairman NIRC and past Central Council member, and all distinguished guests sitting of the dais, senior and the upcoming generation of the ICSI. Well, as detailed out all the distinguished guests that we have seen the journey so far, how the IBC and how the registered value has come across all these challenges, and we can take this opportunity from their deliberations that the path is still a long way to covered, and we are there in the being the extended arm of the Honorable NCLT, and not only for the resolution processes also, but for the corporate clients also, in shape of advisory, compliance and the valuation to be done on various aspects. Thank you so much. I hope you had all the great deliberation in the inaugural session, and looking forward for the another coming up couple of technical sessions in the afternoon after tea break. Thank you so much.
Thank you, CS Jatin Singhal, for your heartfelt vote of thanks. We'd like to thank our sponsors, RRR Insolvency Service Expert LLP and Primus Insolvency Resolution and Valuation Private Limited. We would like to thank CS Nisar Ahmed sir, former President ICSI, for articulating the second National Convention of Insolvency Professional and Registered Valuer and guiding during the event. So ladies and gentlemen, before we close this session, may I request everyone to kindly rise for the national anthem. Thank you, everyone. Apologies, we will be cutting off the tea time and we'll be starting with our first panel discussion. So I request all the audience to please be seated as we are going to start our first technical session. Thank you. Thank you, sir. An apology.
Thank you. Thank you very much.
I request audience to please be seated as we are going to start our first technical session. It's time for the first panel discussion of the day. This session delves in one of the most critical aspects of insolvency ecosystem, evolving dynamics and legal framework in insolvency. Today's discussion promises to be enriching and thought-provoking as we explore recent reforms and the challenges in the implementing insolvency law, the transformative role of technology in enhancing the resolution process, opportunities and hurdles in cross-border insolvency and pre-pack insolvency framework, insight into sector-specific challenges, particularly in real estate, MSME, and financial services, future skill and competencies needed to navigate evolving industry expectation. To steer this discussion, we have a distinguished panel of experts whose wealth of experience and perspective will illuminate the path forward.